taking recourse to its powers under the law.
But this is also
Because you're right, one of the issues which has been framed is the power of the EC to decide upon a split in a party.
yes.
But that by itself and per se will not really restrain the authority from proceeding ahead if it has authority to decide that under the law.
I don't dispute that fact, but I'm saying prior to that, there are disqualifications.
So we got your point. Your point really is that on the 29th of June 2022, when this court passed an order, it made the trust vote was not stayed, but it said this would be subject to the outcome of the petitions.
That's right.
Therefore, according to the office of the CM, the proceedings in the assembly are all under really a cloud, or they are subject to the decision of the petition.
Correct.
And therefore, according to you, the proceedings before the ECI are an offshoot of what has happened before. Therefore, they shouldn't go on pending the disposal of the reference. That really is the sum and substance of your argument.
Broadly, that's what I want to submit to your law.
Yes.
Now, kindly look at it this way. In the meantime, under the 10th schedule, they are members of the original political party. This is very important. 10th schedule does not recognize a split. It used to recognize a split, when Para 3 was there.
But post 2003, Para 3 go.
1st of January 2004, it was removed.
Original political party as legislators, not as members.
Yes.
Legislators.
Correct. Therefore, the original
that's under question.
Yes. Now, that means he is a member of the original political party. Now, if he is a member of the original political party, and there is an issue of disqualification that is pending, whether it's pending or not, that's another issue. That again will have to be looked at. Then, if he is disqualified, having voluntarily given up membership of the party under 21A, and having violated the whip under 21B, this all happened prior to 19th of July, when he moved the Election Commission. And your Lordship knows, in Rajendra Rana, your Lordships have held, the date of the decision will relate back to the act of disqualification. The day when that act took place. Now, kindly have a look at the 10th schedule with me. Your Lordship knows, as a matter of law, that when any legislative party and members of the legislative party who are members of the House, the Speaker of the Assembly is conveyed those who are office bearers within the House, namely the whip. Who is the whip? That's conveyed to the Speaker. The whip, the chief whip. They continue to be members of the original political party while that whip is operating. They can't claim themselves to be a faction. So the 10th schedule doesn't recognize that. Election Commission does. The 10th schedule does not. So if you say that you are a separate faction, while you are a member of the original political party, according to me, you've given up membership of the party. There's nothing more to be done. Because all of these are admitted documents for this is not evidence.
Therefore, Mr. Sibal, the position really is this, that the 10th schedule post 1/1/2004 does not recognize a faction or the 1/3 split which it recognized prior to 1/1/2004 is now no longer recognized by the 10th schedule. On the other hand, you do have the 1968 order, the symbols order, which contemplates that there could be more than one faction of a political party. Now, the 1968 order governs a political party. The ambit of the disqualification provisions of the 10th schedule is the legislative party, the legislature party, right? Because the speaker, in the course of his authority to decide whether there is a disqualification or otherwise, cannot let in evidence saliente to decide as to whether a group of persons are or are not members of the wider political unit called the political party.
No, it does. It does.
That is
to one aid.
Can the speaker, for instance,
Yes.
We note from the written submissions, we are putting this to you because now we have the benefit of seeing the written submissions which have been formulated earlier.
Correct.
They say, for instance, that we have produced 1.5 lakh affidavits of members of the party saying that there is a faction which is represented by them. Now, does the speaker have the power to let in evidence to decide this process which would otherwise fall within the ambit of the EC?
No.
Now, therefore, we have to define, even for the purposes of your interim application, what is the ambit of the jurisdiction of the speaker on the one hand, and what is the ambit on the other hand of the jurisdiction of the election commission.
Correct.
In terms of the symbol order.
Right.
Because the political unit called the political party is a much wider configuration than the legislative unit of that party, which consists of the elected members.
I'm not arguing with us.
Now, does it dispute in regard to the former or the legislative party affect the authority of the election commission to decide the latter?
Yes.
That is really the heart of the matter that we have.
I will answer that immediately, but let's now see what.
Let's have a look at the 10th schedule. We'll
Yes,
bring
what
some
is the
clarity to our
jurisdiction of the speaker? Look at 218.
218, right?
First, let's see the definition. First, look at 1B, legislature parties. The definition of that. 1B. Legislature party in relation to a member of a house belonging to any political party in accordance with the provisions of paragraph 2. Paragraph 4 means, paragraph 3 is omitted if you notice. Means the group consisting of all the members of that house for the time being belonging to that party in accordance with the said provisions.
Member of the house is also.
Member of the house is very important. And it says, it uses the expression member of a house and member of that house on two occasions. So legislature party in relation to a member of a house.
Correct.
Belonging to any political party.
That political.
So it distinguishes it says any political party in the first part.
Yes.
So the definition distinguishes between a member of a house belonging to any political party.
Correct.
With the group consisting of all the members of that house for the time being belonging to that political
That's
party.
correct. So, Malad, if it is
And
Shiv
group of
Sena,
that house.
if it is Shiv Sena, it is Shiv Sena. If it's BJP, it's BJP. Because they have fought the election on a BJP symbol or a Shiv Sena symbol, and therefore they belong to that political party.
So we'll really have to then look at what is the ambit of the disqualification provisions and then contrast it or see if there's an overlap with the
That's right.
1968.
That's why I said that if ultimately we have to decide all this, we are really going into.
So really the ambit in our eye is short. So according to you, one does spill over onto the other. You can't decide that as the election commission without having to comment on the disqualification, which is an issue pending before the Supreme Court.
This is the point.
That is the point.
Now, kindly see whether.
Now let's see 218.
Yeah, no. First, see
Yeah.
original political party, not 218. One seat. Original political party in relation to a member of a house means the political party to which he belongs for the purposes of 2-1. So he belongs to the Shiv Sena. He is under the discipline of the Shiv Sena, under the control of the Shiv Sena, within the house. He has no other persona. Can't be a faction.
Being a member of the political party,
Yes,
he is a member of the house.
that's good.
So the relationship is with respect to his membership in the house.
With reference to the political party which set him up as a member.
That's it.
That's correct.
But the
So,
schedule,
in fact, Manoj, this is the first time in the Constitution that the term political party is used. Nowhere else in the Constitution
first time.
you find that expression. Now,
In fact, the classical books on constitutional jurisprudence in India all mention that the expression political party has not been defined anywhere at all.
luckily we know something
First
about
time it is in the symbols part, which predates 10th schedule.
Now see Manoj 2-1. Subject to the provisions of 4 and 5. Again, Manoj 3 is missing. A member of a house belonging to any political party. Again, the word any is used. Shall be disqualified for being a member of the house if he has voluntarily given up membership of such political party, not the house. If you're asked an example, I belong to one party. I've been elected on the symbol of that party. I go with a leader of another party to the governor and say, meet him and say, please call the house for the purposes of determining who has the majority. Just give you an example. That act alone will visit me with consequences under 2-1. Plus, your watches must.
Yes, it was. Look at it from this angle. If there is a disciplinary proceeding against a member of a political party, if disciplinary proceedings against the member of a political party and the political party expels him, what is the bearing of that so far as his presence in the house? In Amar Singh, they said he sit only as an unattached member.
Yes,
So therefore, whatever happens in the political party will have no bearing on his position so far as the house is concerned. So he continues to sit as an MLA, but as an unattached member.
Yes.
So therefore, where does the convergence of symbols order and 10th schedule?
But that will not impact the symbols order at all.
No, I'm saying, where does that will not impact?
Yes.
But political party's decision is not impacting 10th schedule. And his removal from the party.
Removal is not voluntary. This is the problem.
That's right.
Yeah.
But still his presence as a
But
MLA
even
continues.
disassociated from the party, he doesn't have to follow the whip of the party because he's been thrown out. So he's not subject to any discipline of the party. Because Lordship will appreciate that when I am thrown out of the party, it's not my voluntary act. I am thrown out by virtue of the fact that the party does not want me for any reason, but the party can proceed for disqualification against me, but they don't do that. So the speaker then says that because you've been thrown out and I've been informed by the whip of the party that you're thrown out, therefore I'll give you a separate seat and I'll call you an unattached member. Then I'm not subject to the whip at all. But then 2-1 he will not come.
Ironically, expulsions are welcome because expulsion doesn't disqualify you. You sit separately, you are expelled. So that is welcome rather than proceed against disqualification.
The question is how he could, Mr. Sibal, the question is how it would, the disqualification would have effect on the symbol order, deciding the dispute with respect to symbol.
No, Manas, Manas, I am member of the original political party. I have been elected on that symbol. I continue to be under the discipline of that party, which are otherwise, Manas, kindly see, I mean, it has just huge consequences. Any assembly can be, any government can be thrown out. Any government can be thrown out in this fashion. What is the constitution meant? People go to the governor and throw out a government which is duly elected by the House, by the people of the country. Is this how the 10th schedule is to work? I have never heard in the democratic world that an elected government for a period of 5 years through these machinations is toppled. Why? Because we are discussing some academic issue about jurisdiction of the election commission. See the heart of the matter. Where is this democracy going? Any government can be thrown out. And then what happens is that you have your own speaker. He will not decide the petition, the disqualification petition, and you merely.
Now,
force the government to do
now,
it.
Mr. Sibal, we have looked at the provisions of the 10th schedule. Could we now go to the powers of the EC? We'll, so that, we have to see the two
I'm going to
sets of.
do that. Just allow me a little.
Yes.
So, Manas, therefore, 218 deals with giving up voluntary membership of the party. And 218 if he votes or abstains from voting in such house, contrary to any direction issued by the political party. So, Manas, I am the whip. The whip says you have to vote for the speaker, this candidate for the office of the speaker. They vote for a BJP candidate. Now, all this happens after 29th. Which is all the subject matter of this court's order. Which he belongs or by any person or authority authorized by it in this behalf without obtaining in either case the prior permission of such political party. Person or authority and such voting or abstention has not been condoned by such political party, person or authority within 15 days from the date of such voting or abstention. So if somebody votes contrary, it can still be condoned by the political party. What it tells you is that the political party is in control. See the expression, condoned by such political party, not by a member of the House or obviously. Well, that's kindly appreciate it this way. Legislative members of a political party function within the overall control of the political party. They are representatives of the country. They are not independent of that party. So the political party will then communicate to the chief whip, condone what he did. I mean, he didn't vote for us, doesn't matter. We don't want to take any action against him. Or he didn't come for voting, doesn't matter. It happens many a times. But there's an umbilical cord link between the member of the legislature and the political party. They're not separate issues. There are issues that your lordships will have to decide, which is what I said. Ultimately, those decisions will have to be taken by your lordships in the overall context. It can't possibly be, assuming whether your lordships were to, your lordships were to allow the election commission to go on, proceedings to go on. Some decision is taken. Let's assume that. Well, and in the meantime, these proceedings take place and he's disqualified. What's the consequence? These are issues of great moment for our democracy. Can we see, Explanation. This is also important. Explanation for the purposes of this subparagraph means an elected member of a house shall be deemed to belong to the political party, if any, by which he was set up as a candidate for election as such member. He can't say that I am a different faction now. He can't say that. Now, that's the next point I want to urge before your lordship is this. Any defense of a member of a legislature belonging to a political party for the purposes of protecting himself from disqualification can only be available under the 10th schedule and in no other form. If I move for disqualification, which I moved much earlier, he will have a defense under the 10th schedule. He cannot seek a declaration. And his only defense under the 10th schedule is a murder. There is no other defense available under the 10th schedule. Now, it is the admitted position that there is no merger. So he has no defense. Till the 19th of July, when he went to the election commission, he has no defense. Now he wants to, what does he want to do? He wants to go to the election commission and say that I am the political party. But much before that, his acts and the legality of his acts as a member of the House and as a member of the political party are in question, which has to be decided in these proceedings. What he does is, he says that I am 40, 39 plus 1, Eknath Shinde plus 39. I am a majority in the legislative wing of the party. Therefore, I don't recognize it. What he's saying. That he can't do under the 10th schedule.
Yes, Mr.
No, it's one point. Now your lordship asked me, what is the relationship between this and the symbols order?
Right.
That's come.
Where is the symbols order?
Yes.
1868.
ये compilation भी होगा.
Now see the symbols order. Para 15.
Sure. Have you mixed it in your
Compilation of statutes.
It's in our written submission.
It's in your written submissions already. Yes, there's a compilation by the Election Commission. Murari bhai, आपको मिला?
Page आप 493.
हम थोड़ा उठेंगे ना ज्ञान.
Yes.
सुनो.
Compile it.
When we wake.
Even a compilation of statutes for us, rules and research materials. That has everything.
You got compilation of documents from Ejection Commission also.
Sorry? Yes.
But it's very-
Soon, iPad this.
Two of our convenience compilation. Compilation of documents in legal 3.5.
Para 15 can be taken from several compilations.
Para 15
Yes,
is there,
anywhere.
data in your return submission, para 3.2.
And also para 9, Lordship may kindly see, para 9 at page 5.
It will remain the same. Change. But para 15 will remain the same in all these compilations.
Correct.
The gloss on para 15 may change depending on what you're reading.
Depends how you
But the
look at,
original.
how you read and how you look at.
That's correct.
No, actually, as the copyright.
All right, we'll read paragraph 15.
Now see, when the commission is satisfied on information in its possession,
Some, 1 minute.
is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. The commission may, after taking into account all the available facts and circumstances of the case, and hearing such representatives of the sections or groups and other persons as desired to be heard, decide that one such rival section or group or none of such rival sections or groups is that recognized political party, and the decision of the commission shall be binding on all such rival sections or groups. So let me, see us put forth a situation where there is no dispute as far as the legislature is concerned. There are factions within the party, each of them claiming to be that party. And without any reference to what's happened in the House of this, they go to the election commission and say, we are approved. Election commission can decide.
1 minute. So.
Now let's see. At what point in time does paragraph 15 operate? On the date when he files this application. That is 19th of July. Correct, Manoj? Can't be before that. Even if the election commission were to decide, it could only decide on 19th of July when he moves the election commission. But as far as disqualification is concerned, it relates back to the date when he acted under the 10th schedule, contrary to either the whip or having given up membership of the party. So his status to move on the 19th of July will depend on your lordship's decision whether he stands disqualified or not, and he's likely to be voluntarily given up membership of the party. Voluntarily given up membership of the party, which is the decision of a constitutional authority. Then how do we move the election commission? And the election commission has no jurisdiction to decide whether he is a member or not. Para 15 will operate when both sides agree that they are members of the party. It has to be that way. Because he's claiming that I belong to a rival faction within the party. And he's claiming majority within the party. So where is the question, Manoj, of paragraph 15 operating at all in this case? Therefore, Manoj, to say that paragraph 15 is operative and is independent of all this, with the greatest respect, Manoj, is contrary to the very scheme of the 10th schedule and the scheme of paragraph 15. Because paragraph 15 proceeds on the basis that you belong to the same political party and sections of a political party. If I have thrown you out, supposing I have thrown a person out, he can't move. He's voluntarily given up membership of the party. He can't move. And that's the decision of a constitutional authority. The election commission of India will decide much later. The question
Yes. Mr. Sibal, what's the next point now? We've got this part, this limb of your arguments here.
Yeah, so therefore, this is one part of it. Therefore, paragraph 15 doesn't come into play at all.
Right.
Now, let's look at it on basic principles. We are here because there's a prima facie case. Slowly, matter is pending. It is referred to a constitutional bench. Surely, the strong prima facie case, otherwise, it would not be sitting here. 2, what's the balance of convenience today? That so far the election commission has not proceeded and the matter is listed for hearing. And there is nothing that's happening. No election that's happening. In the Bombay High Court, there is a stay of the BMC election. Yes. Supreme Court.
Now, the stay on the elections to the BMC has come about as a result of which order?
Supreme Court.
The court, this court's order,
Supreme Court.
not the Bombay High Court.
There is no stay at all.
There is no stay of PMC election.
In one of the submissions I read yesterday, that they have said that there was a stay for a period of 5 weeks. That's what they have said.
If they produce the order, there is no stay.
The best of
Hold on.
there is no stay today.
The matter is coming up tomorrow in the High Court. And the state and Maharashtra Supreme before court number 2. State is asking for time of 2 weeks.
In the Bombay High Court.
Yeah.
Oh, yeah.
Yes.
That order is passed on 22nd August 22 in SLP number 19756 of 21. I can't understand why there is a chorus of
Dr. Singhi, SLP.
SLP 19756 of 21 by your lordship's 22nd August 22, titled Rahul Ramesh Bagh versus State of Maharashtra.
And they have asked for 2 weeks' time.
But I beg your pardon, Manoj, that's the OBC reservation matter, nothing to do with the, my learned friends are thoroughly confused.
Totally wrong, Lord. PMC election, the state came out with an amendment that was specifically challenged by us for directed status for my learned friend is not appearing in that matter, so he doesn't know.
No, I'm not.